Hi, my name is John Goralka, and I am the founder of the Goralka Law Firm. Does your estate plan protect your IRAs, 401ks, and other retirement accounts? For many of my clients, their most significant assets or wealth are held in retirement accounts such as IRAs, 401ks, 457, or 403b plans. These accounts are truly special because the accounts compound or grow on a tax-deferred basis until they attain the age of 70 and a half. At 70 and a half, required minimum distributions must be taken, causing income tax to be paid. For a married couple, Joe and Martha, if Joe dies and Martha inherits that IRA, she could use her age or Joe's age to determine the required minimum distributions. When Joe and Martha both die, the free ride was over and the kids had to pay tax on the entire balance of the account over a 5-year period. In 2003, the rules changed for IRAs. In 2006, the rules changed for corporate and governmental retirement accounts such as 401k, 457, and 403bs. Now, when Joe and Martha die, the kids could use their ages for the required minimum distributions. This is truly a dramatic change. My son Patrick is 21 years old. If I die, Patrick could have my retirement account and funds grow on a tax-deferred basis for 49 years. The numbers are truly staggering. If a 50-year-old child inherits a $200,000 IRA, which is growing at 6%, then that child could elect to receive $700,000 in required minimum distributions over 30 years, and there would still be $300,000 left in that account. That $200,000 IRA is really worth $1 million. The rule of thumb is that you will see growth of 4 to 5 times with each generation. This increase in value is often called the stretch out. The problem is that we have 3 choices with your retirement account planning. First, I can name my children as my individual beneficiaries. My children could elect to receive their entire account in cash. If so, the increase in value or stretch out would be forever lost. This is a blowout, very much like a tire deflating that cannot be repaired. Even if they elect to defer that tax and achieve the stretch out, the United States Supreme Court ruled just 8 months ago that there is no creditor protection for an inherited IRA. These accounts and assets are subject to claims, bankruptcy, lawsuits, and even divorce. The second choice is to make a living trust the beneficiary of the retirement accounts. We can even establish a living trust with embedded provisions to protect the beneficiary's assets from divorce, lawsuits, bankruptcy, and claims. However, there is a heavy price. A living trust will typically not qualify to defer the tax and stretch out the benefits, resulting in the blowout. The third choice is to use an IRA inheritance trust. With this trust, we can defer the tax and even appoint a trustee to be sure that the stretch out is elected. The IRA Inheritance Trust can also include the protective provisions to better protect your loved ones from divorce, lawsuit, bankruptcy, and claims. This is very important in today's world. I believe that we may be the very first generation to worry that our kids will be less successful than ourselves. This is because we pay much higher income taxes. Everything is more expensive now. Cars cost what I think a house used to cost. The student loan debt in this country is so high that it is actually affecting the housing market. Kids graduate from college with tens or hundreds of thousands of dollars in debt. They can't save for a house, let alone save for retirement. Also, many of the big pension plans for large employers are shrinking or going away. The IRA Inheritance Trust is an opportunity for you to help your children establish a retirement and move substantial wealth from one generation to the next with minimal income tax. Call the Goralka Law Firm to learn if the IRA Inheritance Trust is appropriate for you and your family.